The knock wasn't loud, it was controlled, like someone who could stand there all morning without changing expression. I opened the door in socks, one hand still on my phone. The man on the porch wore a gray windbreaker and held a thick envelope with a red stripe across the top. He didn't introduce himself the way people do when they want to be liked. He looked down at a clipboard, then at me. "Daniel Mercer?" I nodded once. That was enough. "I'm a process server, you've been served." He offered the envelope with 2 fingers as if it was already evidence. I took it and felt the weight before I read anything. Paper, staples, the clean stiffness of a courthouse print job. He pointed to a line on his clipboard. "Sign here, just acknowledging receipt." I signed. He tore off a copy, handed it to me, and walked back down my steps without looking around. I shut the door and stood in my entryway, envelope in hand, listening for the sound of his car leaving. When it did, I peeled the flap open and slid the documents onto my kitchen table. The first page was a notice of hearing. Bold, centered, probate division, emergency petition, hearing scheduled for 11:15 a.m. Same day, the word emergency was stamped in red across the top, like someone wanted it to be visible from across the room. The case caption had my father's name in it, in the matter of the estate of Thomas Mercer. Below that, in smaller print, petition for enforcement of settlement agreement and immediate surrender of property. I read it once, then again more slowly. There was no settlement agreement that I had signed. There was no property I was supposed to surrender. The petition alleged I had agreed to relinquish my interest in the family house and in a trust account, and that I was now refusing to comply. The petitioner was my sister, Erin Mercer. The petition was signed by an attorney I recognized by reputation, not by personal contact. She had attached exhibits. A copy of an alleged agreement bearing my printed name and a signature that resembled mine if someone had studied it for 5 minutes. A notary block. A list of breaches including my unauthorized entry into the house and my attempt to access accounts. I hadn't entered the house in 8 years. I hadn't attempted to access any accounts. I didn't even know which bank my father used most recently because he changed institutions the way some people change phone carriers. At the bottom of the notice there was another line, casual in its threat. Failure to appear may result in sanctions, fees, and issuance of a writ of possession. They were just trying to embarrass me. They were trying to use the court to make me leave my own rented apartment if they could argue I was squatting somewhere else, or to put a sheriff at a door I hadn't been near. My phone buzzed once, then again. A voicemail notification and then a call from a number I didn't recognize. I let it ring twice before answering. "Mr. Mercer?" a woman asked. Her voice had the calm pacing of a call center script with the edges filed off. "This is Natalie from Heritage Federal. I'm calling regarding a restriction placed on your accounts." "My accounts?" I said. "I don't have accounts with Heritage Federal." There was a pause, and I could hear typing. "You're listed as an authorized signer on an account that was recently flagged," she said. "The account is under the Thomas Mercer Family Trust." My mouth went dry in a way that had nothing to do with fear. It had to do with recognizing a mechanism moving. "I'm not an authorized signer," I said. "I'm a beneficiary. Or I was, unless someone changed something." "I can't discuss beneficiary details," she replied. "But I can confirm your name is attached, and there was activity that triggered a review. A cashier's check was requested this morning." "This morning," I repeated. "Yes, sir, at 8:42 a.m. A request was submitted for a cashier's check in the amount of $85,000. I looked at the documents on my table. The process server had been at my door at 9:05. Someone had moved money, then moved paper. "I didn't request it," I said. "I understand," she replied. Still calm, "That's why I'm calling. We placed a temporary restriction pending verification. If you believe your identity is being used fraudulently, you may wish to file a police report. Also, I see a court order attached to the account profile." "A court order?" I asked. "Yes, sir, an order appointing Erin Mercer as sole trustee, effective last week. It includes language directing the bank to comply with her instructions. Last week, my father had been dead for 3 months. Can you email me what you can legally send?" I said. "Today, immediately." "I can send a redacted copy of the order," she said. "And a transaction summary. Do you have an email address?" I gave it to her. She repeated it back accurately, then said, "You should also know that there's a note in the account profile stating you are not to be given access without trustee approval." "Who put that note?" I asked. "I can't disclose that," she said, then softened the tone by a fraction. "But I can tell you it was entered yesterday at 4:18 p.m. Yesterday." I thanked her without meaning it, and ended the call. The envelope on my table wasn't just a lawsuit, it was a lever. Erin had gotten something from the court, enough to make a bank obey. Now she was using the same court to establish that any resistance from me was breach and non-compliance. I sat down and read the petition again, slower, as if it might change under scrutiny. In paragraph 7, Erin alleged that on the night of my father's funeral we had met privately and resolved outstanding disputes. She wrote that I had acknowledged past misconduct and agreed to accept a one-time payment of $10,000 in exchange for relinquishing all claims. I stared at that sentence until the words blurred slightly, not from emotion but from the arithmetic of it. $10,000 for a house in a neighborhood that had doubled in value, and for a trust account that could generate a cashier's check for $85,000 without emptying it. The exhibit attached to support this claim was titled Settlement Agreement and Disclaimer of Interest. The date on it was 2 days after my father died. It had a notary stamp from a mobile notary service and a signature that wasn't mine. Close enough to fool someone glancing at a file, but wrong in the way a copy key is wrong if you actually try to use it. There was an acknowledgement line beneath it. Respondent affirms he has received independent legal advice. I hadn't. I checked the notary block. It listed a commission number and an expiration date. There was a name, Carla B. Sanchez, Notary Public. I turned the page and found a second exhibit, proof of service. It was a declaration from a process server stating I had been served with the settlement agreement, and that I had signed an acknowledgement. It listed an address that wasn't mine. It was my father's old address, the house I hadn't entered in 8 years. They weren't just forging a signature, they were building a procedural story. Daniel was served, Daniel signed. Daniel agreed, Daniel breached. I looked at the clock. 9:17 a.m. The hearing was at 11:15. There are two kinds of panic. The first is noise, the second is math. I chose math. I opened my laptop and pulled up the county court's case search portal. The petition had a case number. I typed it in and hit search. The docket loaded with the neutral indifference of a system that doesn't care who is lying, only who filed first. Petition filed, 8:51 a.m. emergency hearing set. 9:02 a.m. order appointing Erin Mercer as sole trustee, filed last week, granted the same day. Attached to the trust order was an affidavit titled, Statement of Heirship and Non-Existence of Other Beneficiaries. I clicked it. My name was not on it. The affidavit listed Erin as only living child of Thomas Mercer, only living child. I read it twice, then scrolled to the signature line, Erin's name, her signature, not forged, just hers. Under oath, my phone buzzed again. This time it was a text from a number I knew but hadn't seen in years. Unknown to my phone's label, familiar to my memory. Don't make this harder than it has to be. Just sign what you already agreed to. Court is not going to go your way. I didn't respond. I took a screenshot and emailed it to myself with the subject line, Erin text, 9:19 a.m. Then I called the only attorney whose number I still had saved, a man named Victor Sue who had helped me years ago with a property dispute that had nothing to do with my family. I hadn't spoken to him since. I didn't know if the number still worked. He rang twice. Victor Sue. Victor, it's Daniel Mercer, I said. I need 10 minutes immediately. Emergency probate hearing at 11:15. My sister filed a petition based on forged documents. There was a pause, then a breath that sounded like he had stood up. Email me everything you have, he said. Notice, petition, exhibits. Also tell me which courthouse. I told him. I forwarded the documents as PDFs from my phone, photographed on the table because I didn't have time to scan. Do you have any proof it's forged, he asked. I have proof I didn't sign, I said. That's not proof, he replied, not unkindly. We need something the court can touch. Notary log, metadata, service defects, anything procedural. Procedural, that was the word. Proof of service lists the wrong address, I said. It claims I was served at my father's house. I don't live there. Can you prove your address? He asked. I have a lease and utility bills. Good, he said. Also, does it say you were personally served or substituted or posted? Personally served, I said. Then the process server's declaration is false if it lists an address you didn't inhabit, Victor said. We can attack service. Courts take service seriously because it's their gatekeeping. I watched the clock. 9:26 a.m. I also got a call from a bank, I added. They froze a trust account because someone requested a cashier's check at 8:42 a.m. Erin was appointed sole trustee last week. I'm listed as authorized signer, but there's a note stating I'm not to be given access. Email me the bank contact and any redacted order, he said. Also, I need you to do something uncomfortable. Tell me. Go to the courthouse early. Get copies from the clerk. Certified if possible. We need the original exhibits in their filed form. Sometimes what gets filed has extra data. Also, ask for the notary's commission info. It should be on the document. I can do that, I said. And Daniel, he added, do not contact your sister. I wasn't going to, I said. Victor exhaled again, then his voice shifted into a different mode, the one attorneys use when they're about to spend your time like currency. I'm going to appear with you if I can get there, he said, but I'm 40 minutes away. If I can't, you may have to request a continuance. They stamped emergency, I said. Emergency motions get filed by people who want speed more than truth, he replied. Judges still require due process. Your job is to show the judge that due process is missing. I ended the call and stood up. The next 90 minutes were just logistics. I printed my lease, I opened my utility account and printed a statement with my address. I pulled up my phone's location history for the day my sister claimed I signed her settlement agreement. I didn't know if a judge would care about a phone map, but I knew it was a timestamp. I took screenshots showing I was in another city that day. Then I opened my email and saw Natalie from Heritage Federal had already sent something. A PDF titled Court Order, Redacted. It was the order appointing Aaron Mercer as sole trustee. The judge's signature was visible. The language was standard enough, but in the attached affidavit the sentence "only living child" was visible, because it wasn't redacted. I stared at it and felt something settle in me. Not anger, recognition. Erin hadn't just been opportunistic, she had been systematic. She had used a sworn affidavit to erase me on paper, and she had done it because she believed paper was reality. I grabbed my keys and left. The courthouse was 20 minutes away if the lights were generous. They weren't. I parked in the second level of a garage that smelled like brake dust and stale rain. As I walked, I kept my documents pressed between my arm and my ribs so they wouldn't bend. I wasn't protecting paper. I was protecting timing. Inside the courthouse, the security line moved with the slow confidence of bureaucracy. I watched the clock above the metal detector. 10:12 a.m. The guard waved me through after my belt beeped. I went upstairs to the probate clerk's office, found the window labeled Records, and slid my ID under the glass. I need copies from case number PR-26-04173, I said. The clerk's eyes moved in the way clerk's eyes move when they're scanning for whether you're the kind of person who causes a scene. Are you a party? She asked. I'm the respondent, I said. Emergency hearing at 11:15, she typed. The printer behind her started its steady mechanical rhythm. These will be uncertified copies, she said. That's fine, I replied. I also need the filing receipt showing timestamp. She hesitated, then printed another page. I watched her staple the documents and slide them under the glass. As I pulled them toward me, I noticed something I hadn't seen in my kitchen copies, the e-filing confirmation sheet. It included the filer's account name and email and a small line at the bottom. Filed by Aaron Mercer, self-represented. But the email wasn't Aaron's, it was a law firm domain. The same law firm name was on the petition's signature line as attorney of record. So Aaron hadn't filed self-represented. She had used the firm's portal but labeled herself pro se, or the system had recorded it wrong, or someone had clicked the wrong option. Either way, it was a procedural inconsistency. A small crack. I flicked through the exhibits again. The notary block was clearer on the court copy. It showed the notary commission number. I took a photo. Then I walked down the hallway to a small office with a sign. Notary commission records. I didn't know if they would help me. I also didn't have time to argue. Inside, a woman sat behind a desk with stacks of files arranged like they were holding back water. I approached and said, I need to verify a notary commission number on a document filed in court today. She looked at the number on my phone and typed it into her system without asking why. Carla Beatriz Sanchez, she said. Commission active, expires next year. Does your office keep journals? I asked. We don't keep journals, she replied. Notaries are required to keep their own. If there's an allegation of misconduct, you file a complaint, and an investigator can subpoena the journal. I didn't have time for an investigator. Is the notary required to record the method of notarization? I asked. In-person versus remote? Yes, she said. If it's remote online notarization, it's different procedures, and they must use an approved platform. I held up the exhibit. This claims in-person notarization, I said. But the stamp looks like a remote template. She leaned forward and squinted. That stamp is generic, she said. I can't tell, but if you believe it's fraudulent, bring it to the judge. Judges can refer it. Referral. Not my job to prosecute. My job to survive the hearing. I thanked her and walked out. In the hallway, my phone buzzed with a new email. Victor. On my way. If I'm late, go in and request continuance based on emergency service today, and need time to respond. Mention defective service address, and new evidence of affidavit. Do not argue facts yet. Focus on due process. I read it twice, and tucked my phone away. Outside courtroom, 3B, people sat on benches with folders on their laps. Quiet faces. The air had that specific courthouse smell, paper, disinfectant, and waiting. Erin was there. She sat near the front, legs crossed, posture controlled. She wore a cream-colored blouse and a thin gold chain. Her hair was pinned back the way she used to pin it back in high school, when she wanted teachers to see her as responsible. Next to her was her attorney, a woman in a dark suit with a folder open on her knee. Erin saw me and let her eyes take inventory. She didn't look surprised, which meant she had expected me to show. Or she had trained herself to look like she expected everything. Her mouth lifted slightly. Not a smile of warmth. A signal. She didn't wave, she didn't speak. She just held the expression for a second and then returned her attention to her attorney. I sat on the opposite side of the hallway, opened my folder, and arranged my documents in a sequence that made sense to me. Notice, petition, affidavit, thank order, proof of service, lease, utility bill, screenshots. The bailiff opened the courtroom door and called out the docket number. PR-26-04173, he said. Mercer Estate. Erin stood immediately. Her attorney stood with her. I stood too alone and walked in. The courtroom was smaller than television suggests. No wood-paneled theatrics. Just neutral walls, a seal, a raised bench, and chairs that had been sat in by every kind of person. The judge entered from a side door and sat down. He was older, gray hair, glasses, the kind of face that looked like it had learned to separate stories from records. All right, he said. Looking down at his screen. Matter of the estate of Thomas Mercer. Petition for enforcement of settlement agreement and immediate surrender of property. He glanced up. Appearances, he said. Erin's attorney spoke. Good morning, Your Honor. Melissa Grant on behalf of petitioner Erin Mercer. The judge nodded. Then his eyes moved to me. And for respondent, he said. I stood. Daniel Mercer, I said. I'm the respondent. I was served this morning. The judge's eyes narrowed slightly, not in suspicion, but in focus. He glanced down again, then back up. Daniel Mercer, he repeated, and his voice carried the name through the room in a way that made it part of the record, not just sound. You are present. Erin's face changed in a single controlled motion. The small confidence at the corner of her mouth disappeared as if someone had wiped it clean. Her eyes flicked toward her attorney, then back to the judge. She didn't look angry, she looked recalculating. The judge turned back to the screen. I'm looking at an emergency request filed this morning, he said. Petitioner seeks a writ of possession and enforcement of an agreement allegedly executed by respondent. He looked up at Erin's attorney. Ms. Grant, he said. This is an emergency hearing. What is the emergency? Melissa Grant stood and spoke smoothly. Your Honor, the emergency is that respondent has refused to comply with a signed settlement agreement and has indicated he will interfere with the estate property. Petitioner needs immediate relief to protect assets. The judge's gaze moved to me. Mr. Mercer, he said, you've heard the request. Do you have counsel? Counsel is en route, I said. I spoke with an attorney as soon as I was served. He's driving here now. I'm requesting a continuance. I was served at my residence at 9:05 a.m. for a hearing at 11:15 a.m., and I have evidence of defective service in the underlying documents and of a sworn affidavit that contains false statements. The judge's eyes moved again, quicker. Defective service, he repeated. Explain. The exhibit labeled proof of service for the alleged settlement agreement states I was personally served at my father's house. I said. I do not live there. I have a lease and utility statement proving my address. I was served today at my actual residence for this hearing, not for that agreement. Melissa Grant's face didn't move much, but her eyes shifted slightly toward Erin. Your Honor, she said, the agreement was executed with a notary. The respondent acknowledged it. He cannot now claim he didn't receive it. The judge held up a hand. I'm not interested in argument yet, he said. I'm interested in whether due process was satisfied. He looked at me. Do you have your lease? He asked. Yes, I said. Approach, he says. I walked forward and handed the bailiff my lease and the utility statement. The judge read them for longer than people expect judges to read in emergency hearings. That was the first sign the speed Aaron wanted was not guaranteed. Ms. Grant, the judge said, the proof of service in this file indicates personal service at an address that does not match the respondent's documented residence. It's possible he was at the property, Melissa Grant said. That's not what personal service is, the judge replied. His voice wasn't loud, it was precise. Personal service is at the person, not at a property. If the declaration is inaccurate, that is a problem. Erin's posture tightened slightly. Her hands moved together in her lap. The judge turned back to me. You said there is a sworn affidavit with false statements, he said. Which affidavit? The affidavit used to obtain the order appointing Erin Mercer as sole trustee, I said. It states she is the only living child of Thomas Mercer. The room went quieter in a way I could measure, because even Melissa Grant stopped moving her papers. The judge looked down at his screen, clicked something, then frowned. Ms. Grant, he said, I have an affidavit here titled Statement of Heirship and Non-Existence of Other Beneficiaries. It indeed states petitioner is the only living child. Melissa Grant's jaw set. Your Honor, that order was issued based on the information available at the time. The judge looked up. Mr. Mercer is sitting here, he said, as if explaining something that should not need explaining. He is alive, he is a child of Thomas Mercer. Is there a dispute about that? Erin's attorney hesitated. Erin didn't speak. No, Your Honor, Melissa Grant said. There is no dispute that he is biologically related. There have been estrangements, and... The judge lifted a hand again. Estrangement does not erase status, he said, and sworn affidavits are not creative writing. Erin's face remained controlled, but her eyes were fixed now, not on me, but on the judge's bench. The judge leaned back slightly. All right, he said. Here is what we are going to do. I am not issuing any writ of possession today. Not on an emergency basis, not with service questions, not with an apparent misstatement in a trustee appointment affidavit. Melissa Grant opened her mouth. The judge continued. This matter is continued, he said, to allow respondent to obtain counsel and file a written response. In the meantime, petitioner is ordered to take no action to transfer, encumber, or withdraw estate or trust assets beyond ordinary expenses without court approval. That sentence was aimed at the bank, even though the bank wasn't in the room. Courts speak to institutions by making the record something institutions can rely on. Erin's attorney said, Your Honor, the petitioner is concerned the respondent will access accounts. The judge looked at me. Mr. Mercer, he said, have you accessed trust accounts? No, I said. I received a call from Heritage Federal this morning informing me a cashier's check was requested at 8:42 a.m. I did not request it. The judge's eyes sharpened again. A cashier's check request, he repeated. Who requested it? I don't know, I said. The bank said there was an order appointing Erin as sole trustee and a note on the account restricting my access. The judge looked at Erin. Ms. Mercer, he said directly, bypassing her attorney. Did you request a cashier's check this morning? Erin stood. For a moment she looked as if she might answer the way she had practiced. Then she chose a different approach. I was handling my father's affairs, she said. There are expenses. What expenses require $85,000 in a cashier's check? The judge asked. Erin's face remained still, but her throat moved when she swallowed. It was not $85,000, she said. The judge didn't react emotionally. He reached for the court file. I am not going to litigate bank transactions without the bank present, he said, but I am going to protect assets. Ms. Brad, I want you to contact the bank today and put them on notice of this court's temporary restraining order regarding trust disbursements. Melissa Grant nodded, but her expression was tight now. The judge looked back to me. Mr. Mercer, he said, your counsel is en route. How long? He texted he is 40 minutes away, I said. I don't know if you will make it before this hearing ends. The judge tapped his pen once. All right, he said. I'll hold the matter briefly to see if counsel arrives, but I am not granting relief today. He looked at Erin again. And Ms. Mercer, he said, the affidavit in the trustee appointment matter concerns me. I want a written explanation filed within 7 days as to how that statement was made under oath. Erin nodded once. Not agreement, compliance. The judge stood slightly, indicating a recess. As the bailiff called for everyone to remain seated, the courtroom door opened and Victor walked in, slightly out of breath but composed, suit jacket on, tie straight. He scanned the room, found me, and took the seat beside me. The judge returned and sat. Counsel has arrived, he said, looking at Victor. Appear. Victor stood. Victor Shue for respondent Daniel Mercer, he said. The judge nodded. Mr. Shue, the judge said, you have walked into the middle of an emergency motion. Respondent challenges service and raises concerns about a prior sworn affidavit. What do you want? Victor didn't waste words. Continuance and an order preserving assets, he said. Also, Your Honor, I request the court review the alleged settlement agreement's notarization and service declarations. There are indications of fabrication. Melissa Grant's posture straightened. Your Honor, those are serious allegations. Victor turned slightly toward the bench. Which is why we would like the court to require petitioner to produce the notary's journal entry and any associated communications with the mobile notary service. He said. If this was properly notarized, producing the journal should be simple. Aaron's eyes shifted again toward Melissa Grant. The judge looked down at the exhibit. The notary is Carla Sanchez, he said. Ms. Grant, can your client produce the notary journal entry? Melissa Grant hesitated, then said, We can attempt, the judge repeated. You are asking me to enforce an agreement based on a notarized signature. Notary journals exist for this reason. The judge looked at Victor. Mr. Sue, anything else? Victor nodded. Your Honor, there is also an issue with the trustee appointment order, he said. The affidavit stated, Ms. Mercer was the only living child. That statement was material. It appears to have been used to obtain unilateral control of trust assets. Melissa Grant said, Your Honor, my firm did not prepare the prior affidavit. Victor didn't look at her. Who prepared it is a question of fact, he said. But it was filed, it was sworn, and it had consequences. The judge nodded once, like someone deciding where to place weight. Here is the order, the judge said. Emergency relief denied. Matter continued. Temporary restraining order entered as to trust and estate assets. Petitioner will produce notary journal entry and mobile notary service records within 14 days. Respondent will file a written response within 14 days. He looked at Aaron, and Ms. Mercer, he said, You will file a declaration explaining the false statement in the heirship affidavit. If it was a mistake, explain how. If it was intentional, understand that this court refers matters to the district attorney when necessary. Aaron's face remained composed, but the controlled confidence was gone. She looked smaller without changing posture, which is what happens when someone realizes paper can also be used against them. The judge continued. One more thing, he said. Ms. Grant, I want to address service. The proof of service in this file indicates personal service at an address not associated with respondent. If a process server swore falsely, that is contempt. If your office submitted that knowingly, that is worse. Melissa Grant's eyes widened by a fraction. Your Honor, we relied on what we were provided, she said. Reliance is not immunity, the judge replied. Verify your declarations. The judge signed the temporary order on the bench and handed it to the clerk. Next matter, he said. We stepped into the hallway and the air felt different, not lighter, just more honest. Aaron and Melissa Grant stood near the courtroom door in low conversation. Aaron didn't look at me. Victor walked me to a bench, took the folder, and read like he was counting defects. He pointed to the e-filing sheet, filed as self-represented, routed through a law firm email. Then the settlement agreement, the signature close enough to delay suspicion, not clean enough to survive scrutiny. He said we weren't starting with emotion or handwriting experts. We were starting with the easiest proof the court respects. Service and notarization. Notary journals, dispatch logs, appointment records. The bank call mattered. A restraining order only works if it reaches the institution. Victor said we don't forward, we serve. He would email and fax it to Heritage Federal's legal department and keep transmission proof. Minutes later his phone buzzed with the trustee appointment file. The affidavit didn't just erase me as a beneficiary, it said Aaron didn't know where I was and hadn't heard from me in over 10 years. I reminded Victor she had texted me that morning. He told me to preserve it in multiple forms because locating me on demand made her affidavit a measurable lie. In the car I cataloged the day by timestamps, cashier's check request, emergency filing, hearing set, service, denial, asset restraint, not emotions, timestamps. Because when someone decides to use a legal system as a weapon against you, the battlefield is not a courtroom, it is a timeline, and the only way to win on that battlefield is to own your timeline before the other side has the chance to rewrite it. I remember sitting in that car and feeling the particular kind of calm that comes not from peace, but from clarity. I wasn't calm because everything was fine. I was calm because I finally understood what was happening and had stopped waiting for people to admit it. The check request had gone through. The filing was in. The hearing was set. Service had been completed, the denial had come down, and the assets that had been quietly positioned to disappear, were now restrained. Every item on that list represented a decision made under pressure, and every one of them had been made correctly in sequence without hesitation. That is the only way a record holds. You don't get to go back and fill in the gaps. You have to be present at every moment, logging every moment, because the other side is counting on you to blink. Victor confirmed the bank received the order. He said it the way he said most things, directly without editorializing, because the facts didn't need help from his tone. The bank had received the order. That meant the asset restraint was in place before the close of business, before a single transfer could be initiated through channels that had already shown signs of unauthorized activity. That timing was not accidental. Victor had spent the previous 36 hours preparing for exactly that sequence, and he had moved in the right order, because he understood that in cases like this, order is everything. You file before they can transfer, you restrain before they can liquidate, you preserve before they can delete. If you do it in the wrong sequence, you are always one step behind someone who has already been running. The check request, he confirmed, had come through trustee credentials from a residential IP. A residential IP, not an office, not a law firm's network, not a financial institution's secure portal, someone's home, someone sitting in a house, using login credentials that did not belong to them, submitting a request that was designed to look authorized because it carried the right name attached to it. That is the architecture of this kind of fraud. It doesn't look like a crime because it wears the clothes of legitimate process. It uses the right terminology. It routes through the right channels. It carries the right signatures. The only way you catch it is by looking at the things that can't be faked: the IP address, the device fingerprint, the time of access, the location data that no one thinks to clean because no one expects anyone to look that closely. Victor looked that closely. From the very beginning, Victor looked that closely. When Grant's office called asking for time to produce the notary journal, I was sitting across from Victor in a conference room that smelled like coffee that had been reheated one too many times. I remember the way he listened to the request. Completely still, pen down, eyes not moving from the middle distance. When the call ended, he set the phone on the table and looked at me and said, "Time is where evidence gets cleaned." He didn't say it dramatically. He said it the way a mechanic tells you that a certain noise from a certain part of the engine means a certain thing, as a diagnosis, not a warning. He had already seen what the request meant. He had already understood that the journal wasn't going to be produced in a form that helped us, because if it could be produced in a form that helped us, they would have produced it already instead of asking for time. The request for time was the tell. The ask for time was the moment the other side confirmed, without meaning to, that there was something in that journal, or something missing from it, that required management before it could be shown to a judge. Victor had already moved for a neutral fiduciary before Grant's office finished making the case for the extension, not after. Before, because he had been 3 moves ahead since the residential IP came up in the bank's access log, and he was not going to give the other side an afternoon, let alone a week, to work on a document that might be the single most important piece of evidence in the case. He told me once that the most dangerous window in any contested matter is the window between request and production. That window is where the story gets rewritten. That window is where the inconvenient entries get blurred, where the dates get corrected, where the handwriting suddenly looks a little different than it did the first time someone flipped through the pages. He said that the job, his job, was to close that window before anyone on the other side realized it was even open. The motion for a neutral fiduciary closed the window. The next hearing shifted power without raising voices. I want to be precise about what that room felt like, because I think people imagine courtrooms as dramatic places, full of objections and outbursts and moments where someone finally breaks down and tells the truth under pressure. That is not what this was. This was a room where a judge had read a file and was waiting, with visible patience wearing thin at the edges, for someone to explain a series of documents that did not explain themselves. She didn't announce that she had already formed a view. She didn't need to. The way she paged through the materials before the session opened, the way she set the journal request to one side, as if she already knew exactly what she was going to say about it, the way she looked at Grant's counsel when the extension was raised again, all of it communicated something that no transcript would fully capture. She had done her homework, and people who have done their homework do not need to raise their voices. She asked for the notary journal. There was a pause that lasted approximately 3 seconds and felt considerably longer. It was lost, not delayed in transit, not misfiled in storage, not temporarily inaccessible due to a clerical issue. Lost, The word was offered with a kind of studied neutrality that was its own form of confession, because anyone who has spent time in rooms where documents are disputed understands that neutral is not how you describe something you expected to produce. Neutral is how you describe something you knew, at some point you were going to have to account for. The judge did not respond with anger. She responded with procedure, which is a far more dangerous thing to face than anger. Anger can be managed. Procedure cannot be appealed to emotionally. Procedure simply moves forward, and where it moves is exactly where it moved that afternoon. Subpoenas issued to the notary service, subpoenas issued to the platform that had hosted the remote session, subpoenas issued to the vendor that maintained the connection logs. An interim trustee appointed effective immediately, with full access to all accounts associated with the estate, and a formal referral, quiet, procedural, devastating in its implications, for review of the false service declaration, and the question of whether the instruments submitted to the court met the standard of the law under which they had been offered. That referral is the part that doesn't get discussed enough. It didn't produce an immediate arrest. It didn't produce a dramatic confrontation in the hallway. What it produced was a file. A file that now sat inside a system that does not forget, attached to names and documents and a timeline that could not be altered after the fact, because the court had already received and logged everything in it. That file would move at its own pace, in its own time. But it would move. Files like that always move. Victor had anticipated the subpoenas, which is why the litigation hold notices had already gone out to 3 separate vendors before the session adjourned. He told me that evening that the moment Grant's office had asked for time, he had understood that any third-party platform holding session data was at risk of a preservation gap, not because the platforms would cooperate with tampering, but because data is routinely purged on schedule, and a schedule doesn't pause for a legal dispute that no one has formally notified the vendor about. The litigation hold closed that door. It locked the logs in place at exactly the moment they existed, before any routine purge could trim them down to something less useful. That is the level at which this case was being fought. Not in arguments, not in the emotional weight of testimony, in notices sent to vendors at precise moments, in IP logs pulled before they cycled, in metadata preserved before it expired, in a motion filed for a neutral fiduciary at the exact point when asking for time revealed that time was what the other side needed to clean something. What happened over the following weeks was not dramatic. It was procedural and relentless, and in its relentlessness it was more effective than any confrontation could have been. The neutral fiduciary came in without agenda and without relationship to anyone in the room. That is the entire point of a neutral fiduciary. They don't have a stake in the story. They open the accounts and they read what is there. They don't interpret. They don't contextualize. They report. What they reported was a pattern that no single document had fully captured on its own, but which became undeniable when every document was laid flat at the same time. Transfer attempts that had not been disclosed, attempts that had been initiated, and in some cases partially processed, through credentials that the account holder, had not used and had not authorized. Platform logs showing access activity on dates and at times that contradicted the declarations that had been submitted to the court. And then sitting in the middle of all of it, the remote notarization session. I want to describe what it means to watch a recording of someone pretending to be you. It is not like watching a forgery on paper. A forged signature is cold. You look at it, you recognize that it isn't yours, and the wrongness of it is immediate but abstract. A recorded session is different. It moves. It speaks. Someone sat in front of a camera and performed an identity. Performed my identity, going through the steps of a notarization process that was designed to look exactly like what it would look like if I had been present and consenting. And the transaction was legitimate. But the platform had captured everything, not just the video, the device, the network, the IP address of the connection, the geographic location resolved from that address, the session timestamp down to the second. Every one of those data points matched something, matched a pattern, matched a location, matched a device, that had nothing to do with me, and everything to do with a sequence of events that had been building since the first unauthorized access appeared in the bank's log. Victor watched the session recording without expression. He said afterward that it was the cleanest piece of evidence he had seen in a case like this, not because it was dramatic, but because it was complete. The platform had preserved it in full. The metadata was intact. The chain of custody was clean. There was nothing the other side could do with it except object on grounds that the judge had already heard and already declined. The false service declaration collapsed under the weight of everything around it. Individually, a false service declaration is serious. In the context of a session recording, unauthorized access logs, a missing notary journal, a residential IP, and transfer attempts that contradicted sworn statements, individually it was serious. Together it was something the court could not treat as an isolated lapse. It was a thread, and the judge had already pulled it, and what came loose when she pulled it was a pattern that could not be explained as coincidence or clerical error or miscommunication. The referral for perjury and false instruments went into the file without ceremony. These things rarely happen with ceremony. They happen the way water moves through a crack in a foundation, quietly, and with consequences that reveal themselves over time rather than all at once. The names attached to those documents were now attached to a referral. The referral was now attached to a court record. The court record was sealed from casual access, but available to every relevant authority that would ever need to ask. That is the architecture of accountability. It is slow, it is procedural, it is profoundly unglamorous, and it works. The court denied Aaron's petition with prejudice. I have thought about those 5 words more times than I can count since the day they appeared in the order. Denied with prejudice, not dismissed without prejudice, which would have left the door cracked open for a refiled version with different framing, a different angle, the same underlying attempt dressed in new paperwork. Denied with prejudice means the court examined what was submitted, examined the foundation it was built on, and determined that the foundation was not fixable, that the petition itself, not just the arguments but the premise, the documents, the claimed authority, was built on material the law would not allow to be reconstructed and resubmitted. The door did not close, the door was locked, and the key was dissolved in the record. Vacating the orders that had been obtained through the false affidavit was the structural consequence of that finding. Every order that had been issued in reliance on that affidavit, every direction to the bank, every instruction to a servicer, every authorization that had flowed downstream from a document the court had now found to be false, was unwound. The scaffolding came down, and what was left standing when the scaffolding came down was not what the other side had built. What was left standing was the original structure, intact, protected now by an interim trustee who had no incentive to manage it for anyone's benefit except the law's. The assets were secured, held outside the reach of the people who had demonstrated through every step of the preceding months that they would use whatever access they had, to whatever instruments were available in whatever way served their objective. The neutral fiduciary held everything. The accounts were frozen for unauthorized activity. The platform access was revoked. The credentials that had been used from a residential IP were invalidated and flagged. Victor said very little when the order came through. He doesn't celebrate in hallways or in conference rooms or in parking lots after hearings. He said the record was clean. He said that a clean record is the only kind worth building, because a clean record doesn't depend on anyone's memory, anyone's goodwill, or anyone's willingness to tell the truth under oath. A clean record exists independently of all of those things. It exists in the way that math exists, not because anyone agrees with it, but because it is what it is, and no one's disagreement changes what it is. He said one other thing. He said that if any single link in the chain had been handled differently, if we had given Grant's office the time they asked for, if the Gation hold had gone out 24 hours later, if the bank's IP log had been treated as a detail rather than a lead, if the motion for a neutral fiduciary had come after the next hearing instead of before it, the record would still have been true, but it would have been incomplete. And incomplete records, he said, are where guilty people live, in the gaps, in the spaces between what can be proven and what can be known. They don't need to rewrite the whole story. They only need to remove enough of the story that the remaining pieces no longer add up to what they added up to before. He had not let that happen. He had treated every gap as a vulnerability before it became one. Every timestamp, every vendor notice, every IP address, every motion filed one move earlier than the other side expected it. All of it was gap management. All of it was the practice of building a record so complete that the only thing the other side could do was sit inside it. That is what I want you to understand, if you have stayed with this story this far. Not the legal terminology, not the procedural mechanics, the principle underneath all of it. Systems can be turned. Legal instruments, the same documents that are supposed to protect people, can be manufactured and submitted and used to erase people. This is not a theoretical risk. It happened. Someone sat in front of a camera and performed my identity. Someone submitted a document to a court that said, I had been served when I had not been served. Someone used trustee credentials from a house to request a cashier's check for money that was not theirs to move. None of those things are abstract. All of them happened in sequence, with paperwork, through channels that were designed to look legitimate because they carried the right names and the right formatting and the right procedural language. The answer to that, the only answer that worked, the only answer that ever works, is documentation built faster and more completely than the fraud can be run. Not anger, not accusation, not the emotional weight of telling a true story to people who have no way to verify whether it is true. I want to be clear about why I am saying that, because it can sound like I am telling you to suppress what you feel. I am not. What I felt during every stage of this was real and none of it was small. But emotion, however justified, is not a legal instrument. It cannot be subpoenaed. It cannot be entered into the record. The other side counts on your emotion. They build their strategy around the assumption that your pain will eventually override your precision. I did not give them that. Victor would not let me give them that. Documentation. The IP log pulled before it cycled, not after, not when it became convenient. Before the routine purge that runs on a schedule, completely indifferent to whether your hearing is next week or your motion hasn't been filed yet. Victor understood that digital evidence does not wait for the litigation to catch up to it. If you are not there before the log cycles, you are left with a gap, and gaps are where the other side builds their version of events. The litigation hold sent before the routine purge ran. The motion for the neutral fiduciary filed before Grant's office finished arguing for an extension that would have given them exactly the time they needed. Every one of those actions was placed into the record at exactly the right moment, before the window closed, before the gap appeared, before someone who knew how to use time had the time they needed. That is the operational summary of this entire case, not reaction, anticipation. Victor moved before the gap appeared, not after it opened. The record finished what family loyalty didn't. I want to sit with that sentence, because it is the truest thing I can say about this experience. There was a version of this story where I waited for acknowledgement, where I believed the shared history would function as a floor beneath which things could not fall, that at some point someone would look at what was being done, the false instruments, the manufactured service, the session recording, the credentials used from a residential IP, and decide the relationship was worth more than whatever they were protecting. I waited for that version. It never came. Not an acknowledgement, not a private conversation, not a moment of someone choosing the truth over the paperwork they had already filed. The record did not have that problem. The record was loyal to exactly one thing: what had actually happened. There was also a version where I spent my energy trying to understand how someone could do this. I chose not to live there, and I recommend the same choice. Understanding why does not unmake the documents. It does not restore the time lost to building a record that should never have been necessary. Every hour spent on how is an hour not spent on what, when, and where, which are the only questions that courts respond to. I lived in the version where Victor logged the IP, moved for the fiduciary, closed the window, and let the session recording say what no personal testimony could have said with the same authority. The platform said it, the bank log said it, the metadata said it, the missing journal said it, in the way that absence speaks louder than presence when the law expects something to be there. A notary journal does not lose itself. It is bound, numbered, retained by statute. When it goes missing, the court does not treat that as an inconvenience. It treats it as a signal, and the judge in that room had already read enough of the file to understand exactly what kind of signal it was. The record spoke, and when the record speaks in full, without gaps, there is no counter-narrative that survives it. A counter-narrative needs space to grow. It needs the gaps between documented facts where an alternative explanation can take root. Victor closed every gap before it became a gap. What was left was not a story anyone was telling. It was a record, and the record was complete. If you are watching this because something in it sounds like your story, if you have watched someone use legal language to perform a legitimacy they do not have, if you have seen instruments designed to protect people turned into instruments of erasure, if you've been told your account is too emotional to be credible while the other side files documents you never signed, then here's what I want to leave you with. The truth alone is not enough. It has never been enough, and pretending otherwise will cost you time. You cannot get back. The truth without documentation is a position. Positions are argued against, reframed, placed inside narratives that make them look like one side of a dispute. Documentation is a record. Records are not argued against. They are either complete, or they are not. The documented truth is enough. The preserved metadata is enough. The litigation hold sent before the purge runs is enough. The motion filed one move ahead of what the other side expects is enough. The neutral party who opens the account and reads what is there, without relationship, without agenda, is enough. Build the record, protect the record, trust the record to say what you cannot say without being dismissed. The record has no stake in the outcome, it has no bias, it does not get emotional on the stand. It simply is, and when it is complete, it is more powerful than anything the other side can say about it, because anything they say is a position, and positions collapse against a record that has no gaps. That is how this ended. Not with a dramatic confrontation. Not with a confession. Not with the satisfaction of watching someone finally admit what they had done. With a judge reading a complete file. With a neutral fiduciary reporting what the accounts actually contained. With a platform log showing a session conducted from a device, a network, and a location that had nothing to do with me, preserved in full because a litigation hold had locked it in place before anyone realized the window was closing. Documents decided this, not speeches, documents. If you have been through something like this, if you have seen a system turn sideways on someone who had no voice in how it was used, share it in the comments. Not to vent, share it because someone's sitting in their car right now, lauding timestamps, wondering if any of this can actually be proven. That person needs to know it can. That the record, built right, protected early, and presented completely, is the most powerful instrument in any room. Subscribe if you follow stories where documentation decides the outcome, because that is the only kind of story I know how to tell. And I am going to keep telling them for as long as there are people who need to hear that the paper trail is not just evidence, it is the path.